My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. First, we hope that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver, Inc. continues to be fully operational. Both Brandon Smith and myself are holding all meetings by telephone or video, and we are available to answer any questions you may have, either about this Brandon blog or anything else at all. So give us a phone call, shoot us a message. We would love to hear from you. Today's Brandon's blog is about an unreported Ontario court decision. The blog is titled Trustee in Bankruptcy, Ontario, the Best Modern Rules for Getting Paid. So I hope you can watch until the end of this video, because I know you will get value from it. This unreported Ontario case was actually the subject matter of a webinar that Brandon and I attended earlier this week. The webinar was presented to the insolvency community in Ontario by our provincial association. There were 3 presenters, a licensed insolvency trustee and 2 insolvency lawyers. It turns out that the trustee was actually the trustee in this case. What this case was about was the trustee going for taxation, having administered a personal Division 1 proposal restructuring under the Bankruptcy and Insolvency Act. This was about a real estate agent who was insolvent, owed a huge debt to Canada Revenue Agency and debts to others, and needed to do a debt settlement plan. The person had too much debt to do a consumer proposal, so they did a Division 1 proposal. The trustee then went to get his accounts taxed. And as you'll see in the blog below, the trustee had difficulty. Normally, it is an over-the-counter taxation. We upload documents to the court electronically, and if there are no issues or problems, the Associate Justice reviews the situation, makes the taxation order, and sends it off to the trustee. If there are any issues, the Associate Justice will make an endorsement, ask questions in order to have fuller information. In this case, the Associate Justice asked questions, wasn't happy with the answers, and then requested a video conference taxation hearing after notice being sent by the trustee to the Office of the Superintendent of Bankruptcy, as well as to all the creditors. Neither the creditors nor the Superintendent of Bankruptcy opposed the taxation, but the court was not satisfied that the trustee had submitted sufficient information to prove that it deserved all of the fees it was asking for. Most importantly, the trustee did not submit any time dockets because they did not have any. The reason they didn't have any was because in the proposal itself, it gave the number, the fee that the trustee was going to charge, and therefore the trustee felt it was a fixed fee and they did not need to keep time dockets. Unfortunately, the court felt otherwise. The court reduced the trustee's fee. The trustee was not happy, appealed the associate justice's decision to a judge on the commercial list, and the judge dismissed the appeal, affirming the decision of the associate justice. All of the details are in the blog below. Brandon first goes through the different types of files a licensed insolvency trustee could administer, which ones, the consumer files, have a fixed fee tariff, and which ones, being all the others, that do not have a fixed fee and therefore require the trustee to keep accurate and detailed time dockets to prove the work done, the value of the work, in order to get through successfully a taxation. So I hope you can read the entire blog below, because I know you will get value from it. Again, the Ira Smith team hopes that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver Inc. remains fully operational. Both Brandon Smith and myself are answering all questions, holding all meetings, either by telephone or video meeting. So give us a phone call, shoot us a message. We would love to hear from you.